Hello and welcome back to Maine Justice. It is our 200th episode. So happy anniversary, Mary McCord, my co-host.
Well, 200 is a lot. Congratulations to you and to the whole team. 200. No wonder we're so tired.
Oh, there's a lot of reasons that we're tired. You know, I'm going to start by just telling one quick anecdote. I still remember the phone call with the head of MS Now. She was the one who came up with the idea of the podcast, then called Prosecuting Donald Trump. And I was like, what are you going to call this podcast? Like two nerds? Who wants to hear this? And she was like, a lot of people want to hear this. And I was like, okay, if you think there's an audience.
And thank you to our listeners. It's been a great ride ever since then. And here we are at 200 episodes. And that's a great segue, Andrew, to what we're talking about today.
Absolutely.
We are talking about Todd Blanche's confirmation hearing, which begins tomorrow.
Wednesday.
That's right. Today is Tuesday. It begins on Wednesday. It'll be a 2-day hearing. And it is very, very important to the place that is the title of our podcast, Maine Justice, because he is nominated to be the head of Maine Justice, the Attorney General of the United States. He's, of course, been the acting Attorney General now for several months, ever since Pam Bondi was fired. He's been the Deputy Attorney General before that, which is really the person who kind of runs the day-to-day of the
Chief Operating Officer.
That's right. Although I think he's been still doing that in his acting AG role, and I can't really see him giving up. And so we think it's very, very important to take a look at some of the issues that we hope that the senators will be pressing Todd Blanche on. And maybe if I could frame it up a little bit, Andrew, as we start to talk about this, there's a lot of things we're going to add to today's episode, including yesterday's just amazing opinion by Judge Kathy Williams in Florida in the case that Donald Trump had brought against the IRS for leaking tax information, the case that was settled. And I'm using little scare quotes around settled because they settled a case before the government ever responded, and something that the judge has now basically said was collusion. It was the president being on both sides of that case, and it's no adversity between the parties. And she sanctions the lawyers involved and makes referrals for bar disciplinary proceedings or investigations. So we will dig into that. We'll dig into some other things that Todd Blanche has been responsible recently, but I think also reflect back on what he's been doing since he transitioned, supposedly, wink, wink, from being the president's personal attorney and criminal defense attorney to being the deputy chief and now chief law enforcement officer in the United States.
And Mary, I have a question for you that I am going to ask you at the end, which is, if you were a senator tomorrow, what is the one question that you would ask Todd Blanche? So I want to come back to that.
That actually leads right into the framing I was going to say. So in January of 2025, I testified on the second day of Pam Bondi's confirmation hearing. And my testimony, which we can include in the show notes, I think is even more relevant today than it was back a year and a half ago, where we still held out some hope that the incoming AG at that time, Pam Bondi, would take seriously her oath to the Constitution. We saw that that didn't really happen. We've seen that Todd Blanche, who also as deputy AG, had to take an oath. Hasn't really happened. But here, there were three things I talked about. I talked about the oath being to the Constitution and not to a president or any one person. And so if what the president wanted the AG to do conflicted with the Constitution wins, not what the president wants. I talked about recusal, where the perception of a conflict or the perception of the attorney general actually being the president's personal lawyer and not the lawyer for the United States might be in order. And in fact, I reflected in that testimony on something that William French Smith, who was nominated by President Ronald Reagan to be attorney general, and William French Smith had been Ronald Reagan's personal attorney, and he was asked during his confirmation hearing how he proposed to ensure that his former relationship would not compromise his independence. And he said, I would have to be very conscious of situations where it could appear that because of that relationship, a problem might be created. He said, certainly if a situation arises involving the president or a member of his family or others in a sensitive situation, I would recuse myself from participating or handling any aspect which might develop out of that situation. Words that I think this nominee should be thinking about. And third and last, I talked about the historic policies since Watergate, which you and I have talked about on the show before, of independence from the White House, the importance of the Department of Justice to exercise its own judgment and not be directed by the president, particularly when it came to investigations and prosecutions, the use of that criminal enforcement authority. And that had been reflected in policies by presidents and attorneys general under Republicans and Democrats ever since Watergate.
Perfect segue to talking about the decision yesterday, a 56-page decision by Judge Kathleen Williams in the so-called slush fund case. So what was before her? Let's try and just focus for a moment exactly what the posture was, because this is something that, Mary, you and I, just before we jumped on, have noted that people are getting wrong out there. So there was a case that Donald Trump, as you said, brought against the IRS. Donald Trump himself, when he brought it, said, isn't this odd? Because I'm on both sides of this case and I could settle it for what I want.
Right.
That sort of is the gist of it. Then that case gets withdrawn by the plaintiffs. They make a motion saying that we'd like to withdraw this case under a specific rule. It is important to note that under that specific rule in a civil case, the judge has very, very little discretion. But what did happen is a number of former judges filed, as friend of the court, amicus brief saying, Judge, you may have very little discretion to dismiss the case at the request of the plaintiffs because they've reached some private agreement or they just don't want the case to go forward. But that does not divest you of looking into whether this was sanctionable, whether this was essentially a fraud on the court. And there are two possible ways that the court actually addresses her power to deal with something if she thinks there's appropriate sanctions. One is under a rule called Rule 11. Mary, you and I are very used to the idea that there can be Rule 11 sanctions. And the court has a separate body of authority to impose sanctions based on the inherent power of the court. So what was before the court was this issue of sanctions if she thought and found that this was a sort of collusive sham lawsuit, which was seeking to have the imprimatur of the court to make it so that it could be talked about as, oh, look, here was a legitimate case that was settled. So you have the language that we've talked about, Mary, could be, oh, there's a case, the case has some merit, and there was a settlement. That's what happens in cases. And this is just a settlement of a legitimate case that Donald Trump had. That was sort of the framing. And the court was being asked, can you look at this? Because that's not what's going on. And she does look at it and she concludes that this is a sham case, that the settlement is not, in fact, a settlement. One of the striking parts of this is she says to the parties, you cannot, in this case and in court, refer to this as a settlement because it isn't. Donald Trump is on both sides of this. One other thing that I thought was just like an ironic skewering is she uses the Supreme Court's own recent decisions saying that Donald Trump is sort of the unitary executive and has complete control. What she says, well, if that's true, not only is Donald Trump then the plaintiff, but he has complete control and he is exercising complete control over the defendant, which is the IRS. So don't pretend that there's a difference between Donald Trump plaintiff and essentially Donald Trump, the alter ego, as the defense. And so that's sort of the posture. She is not saying, and she didn't have the power to say, that the slush fund itself could not go forward in some fashion, or the immunity that Todd Blanche signed could not go forward, although there are very, very interesting ramifications of her decision if Donald Trump were trying to enforce that private agreement between Todd Blanche and Donald Trump giving immunity for tax liability to him, his family, his companies. So fascinating. And it raises so many of the things, Mary, that you discussed in the framing.
Yeah, and it's worth picking this apart even a little bit more, Andrew. I mean, her conclusion, which was your sort of bottom line up front, I want to read and then let's go back and pick apart a little bit how she got there. She said the parties used the existence of federal litigation as a means of conferring legitimacy upon a course of action that they were unwilling to subject to judicial review. And by that, she means you brought this case, plaintiffs being Donald Trump, and his children and the Trump organization, but really she focuses on Donald Trump. You brought this case and then you dismissed this case before the government even responded to it in order to evade judicial review. And she pulls that apart and we can talk about that.
Mary, can I just give one quick illustration of that that's relevant to our theme of Todd Blanche and the confirmation hearing? And this is one where it'd be so great to sit next to you because this is one we highlighted so
Yes.
much.
I know. I almost don't have anything not highlighted in this opinion is a problem.
So footnote 38 is relevant exactly to what you said, Mary, which is talking about Todd Blanche. And I'm just going to read it out loud. Footnote 38. The court is extremely troubled by the testimony given by Acting Attorney General Blanche on May 19th, 2026, in response to why the, quote, settlement agreement, unquote, had not been submitted to the court for review. He stated that, quote, there is no judge, unquote, because the case had been dismissed and therefore there was, quote, no mechanism, unquote, for reviewing the agreement. Now, she says that is just ridiculous because at any time the court was there. And as you and I know, Mary, courts review settlement agreements all the time. This is not something that is foreign. And she said, if Acting Attorney General Blanche had thought the dismissal was improvidently granted or thought plaintiffs misspoke when they said no judicial analysis is appropriate, he only had to file an appearance and ask for relief. And she said that she concluded that Todd Blanche's testimony, just wait for this, Todd Blanche's testimony, the person who is up for confirmation as the head of the Justice Department, she concludes at best misleading and at worst disingenuous. I'm sorry, that is disqualifying.
And part of her reason for this is the timing of that, right? Basically, this is right after the dismissal. There's Todd Blanche saying, what could we do? We didn't have any opportunity for judicial review because there was no judge. And that wasn't on her, right? That was very much on him. She goes on, right? After the sentence I read, she says the context of, then she puts it in quotes, settlement, the relationships of the people involved in negotiating and approving it, the ethical implications of their conduct, and the parties' swift efforts to dismiss this case after the court raised fundamental jurisdictional questions all support this conclusion. Accordingly, the court expressly finds that plaintiffs acted in bad faith, plaintiffs being Donald Trump, his children, and his organization. And here, let's go back again, another point that she dissects, the relationships of the people involved in negotiating and approving it. This is where she does what you indicated. She says the president is on both sides of this. They want to act like this is an ordinary piece of litigation. This is anything other than ordinary. The litigation begins with the president, even though they're trying to claim this was in his private capacity that he brought this litigation. And she goes through the very things that I think, if we look back about what William French Smith said back when Ronald Reagan nominated him, a former personal attorney, to be the attorney general, he says, I would have to be very careful about this, but not so here. We have Todd Blanche, former criminal defense attorney for Donald Trump, being the one that is clearly doing the, I'm going to put these in quotes again, negotiations over the terms of this settlement. The terms being the creation of this $1.776 billion slush fund to pay, quote unquote, victims of weaponization, never denying that those victims might be those who were convicted of attacking the United States Capitol on January 6, 2021. And also, as she says, Blanche and Blanche alone filed the addendum that gave total sort of immunity to Donald Trump, his children, his business organizations, civilly and criminally for anything that they may have done. No more investigations, no more examinations, no more prosecutions, no more civil claims, no more counterclaims, all given up by the Department of Justice, signed by one person, Todd Blanche, in order to give this freedom and release the president and his family and his organizations from examination for anything, including, as so many have reported, IRS audits. And she notes that's Todd Blanche alone. And this is this self-dealing. This is something which William French Smith would have said, I can't do that.
Exactly. And she points out that in spite of the fact that when Todd Blanche first started as the deputy attorney general, that the spokesperson said, oh, he's going to recuse in cases where there's a conflict. But she points out he didn't recuse here. So he is giving immunity to Donald Trump, his family, and his companies, even though he represented them. And this is what she says about the signed immunity order, what she refers to as the release order. She finds, and again, I just want to make sure people understand, this is what she says about that release order. Quote, this provision directly contravenes 26 USC, that's United States Code, section 7217, titled Prohibition on Executive Branch Influence over Taxpayer Audits and Other Investigations. And she notes that that provision says it shall be unlawful for any applicable person to request, directly or indirectly, any officer or employee of the Internal Revenue Service to conduct or terminate an audit or other investigation of any particular taxpayer with respect to the tax liability of such taxpayer. So that's a bit of a mouthful, but that's basically a way of saying we do not want the executive to be directing who gets examined by the IRS and who does not get examined by the IRS. And it's a criminal provision. And so, again, the person who is up for confirmation to be the head of our Justice Department has been found by a federal judge to be in violation by signing that release order of this criminal prohibition.
Yeah, pretty striking stuff. Good fodder for the senators at the confirmation hearing tomorrow. And I want to also, before we break, mention a couple of other things about this opinion, which we could spend, frankly, the entire episode on. There's so much in there. But you raised, Andrew, the fact that she cited a recent Supreme Court case. And I do think this is important. We talked about this case just last week. This is Trump versus Slaughter. This is the case where the Supreme Court held that for all independent agencies other than the Federal Reserve Board, the president has to have the power to remove members of whether it's a multi-member commission like the Federal Trade Commission, which was at issue in Slaughter, or whether it's a single-headed independent agency. Trump has got to be able to remove those people at will if he doesn't think he can work with them. And she quotes this case at least 3 times. The holding that said Article 2 requires that the president control all executive power, especially the authority wielded by agency heads who are the most important of the president's subordinates and who must be the president's alter egos in their agencies. That's her quoting from the Supreme Court decision. And then she says plaintiffs, again, Donald Trump, cannot argue before the Supreme Court that executive branch actors unquestionably exercise executive power and must therefore be controlled by the chief executive, and then here argue that the parties are sufficiently adverse to establish an actual case or controversy. There was no case or controversy. It was a collusive sham investigation. So before we conclude, what was the end result here? Like you said, people have gotten it mistaken in the reporting that she set aside the settlement. She does not use authority to do that. She relies on Rule 11 and her inherent authority to issue sanctions.
Yep. And there are 2 types of sanctions. There's costs, attorney's fees as one, and the other is bar referral sanctions. There's some others, which I talked about, which is not referring to things as a settlement in court. But with respect to the bar referrals, she refers various people out and also has her opinion sent to pending bar associations where there are pending matters. So that happened to Todd Blanche. He has a pending bar complaint, actually several in New York, where he is licensed. So this decision is sent there. That's the same thing with other DOJ people, other people who were lawyers on this case. With respect to costs, she notes that one set of amicus who appeared actually said, you know what? we don't want money here. We may be entitled to it, but we're not doing it for the money. Let me just give a quick shout out to Don Verrilli because he has been such a leader in this area among many, many others.
Yes.
That's just such a contrast in terms of when you think about what this whole lawsuit was about, which was both the immunity piece and how to get tons and tons of taxpayer money for private purposes. Here you have these lawyers going, no, you may say that we're entitled to costs, but we're not asking for it. But there's another group that had not yet taken a position. And she says, I'm giving the parties time to submit briefs on whether they want costs and what the amount is, and both sides can submit on that. And so that's the main issue. She isn't saying, I have power to get rid of the slush fund or I have power to get rid of this so-called immunity release order. But I should note, Mary, that if Donald Trump in the future were to try to use this in connection with some other administration wanting to go forward and look at tax liability, this would be such a powerful decision. I've always thought that that paper signed by Todd Blanche is not worth the paper it's printed on.
Yeah.
And it would just be a horrendous hearing for Trump and for Blanche and for all of the people involved to talk about what happened here. I just thought she was so perceptive to point out that when Todd Blanche showed up in front of Congress and said, we've decided that we're not going forward with the slush fund, she said, oh, that is so indicative of the fact that this isn't a real lawsuit. Because who are you to say that? When you have adversity, one side can't just speak for all parties because there's adversity. And so she's saying this gives up the ghost and the veneer of anything. And when you and I were actually in the business of being prosecutors, one of the ways that we were taught to think about cross-examination of a defendant is that when a defendant is guilty, it's very hard for them to come up with a story where they have to think through what would an innocent person have done. Because if they're guilty, they haven't gone through that whole history of how to think about this as if they were innocent. And here, Todd Blanche acted in a way that demonstrated the collusive nature of this because he hadn't thought through, oh, wait a second. If it was a real lawsuit, I wouldn't be able to just show up and say, by the way, we're not going forward with one piece of this because it wouldn't be his decision. So that was just a brilliant point. Okay, Mary, let's take a break. And then what we'd like to do is we're going to put what happened yesterday in Judge Williams' remarkable decision in context of other things that we think are incredibly pertinent and important for Todd Blanche to be questioned about and get answers at the upcoming confirmation hearing.
Yes, absolutely. Let's do it.
So, Mary, maybe I can give you a quick TikTok. I'm told, by the way, by the youngsters that I can't say that anymore because it doesn't have the meaning that we think of it. But in any event, there is the whole issue about Todd Blanche's conduct in connection with Jeffrey Epstein, the so-called way in which they wanted to pretend to appear that they are transparent when they're not. There's the questioning of Ghislaine Maxwell, and then almost like an immaculate conception where somehow she gets moved to a camp with reports of having a puppy and a yoga mat. There's the effort to indict 6 members of Congress for issuing a video. There's seeking to indict James Comey, not once, but twice. There's the indictment of Letitia James. There's the indictment of Brega Garcia that was set aside for vindictive prosecution, very much set at the feet of Todd Blanche. There is the rejection of grand jury subpoenas of the Federal Reserve, of the sitting Minnesota governor and sitting mayor of Minneapolis. And just recently, as we covered, the election fraud grand jury subpoena in Fulton County, all of which were set aside. That means ended by judges of all political persuasions. The one that we talked about last week was in Fulton County by a judge appointed by Donald Trump, not some rogue judge. There is obviously the slush fund settlement that we just spent a whole segment on. And there's his effort to, I say, obstruct, but certainly not assist the independent investigations at the state level of Alex Preddy and Renee Good by not turning over the federal evidence so that there could be that investigation. That's just a quick TikTok of things. Mary, what would you like to talk about?
Oh my goodness. All of these are things that are worth talking about. So I think the Epstein stuff is going to be really huge at the hearing tomorrow. I know that Bill Kristol and Cyril Longwell have been talking about this on the Bulwark about how July 6th of last year is the date that Pam Bondi came out and said, nothing to see here. We've done an exhaustive investigation. There's no one to charge. There's nothing more. It's over. And at least according to reporting, just within 2 weeks of that, there's a big huddle at the White House in the Situation Room where Todd Blanche is present. And after that, what does he do? He flies down. He does the interview with Ghislaine Maxwell that you have just referred to. She gets transferred to a cushy, to the extent that prisons are cushy, a cushy federal camp prison. We've all seen those transcripts. You and I have talked about them on this podcast. They do not look like an interview that a prosecutor who is intent on getting to the bottom of things would actually do. They look like an interview that was designed for Ghislaine Maxwell to exempt Donald Trump from any scrutiny for his own relationship and knowledge with Jeffrey Epstein and potential knowledge about what Epstein was doing with respect to underage girls.
Can I just foot stomp on something you said with respect to the Situation Room meeting? First, what is Todd Blanche doing there?
Exactly.
That is a political meeting, to your point about independence of the Justice Department. So just his mere presence tells you something. But what is the reporting? The reporting is that, and this is something that was so obvious to you and me, and to frankly anyone who has been a federal prosecutor or even a defense lawyer, which was we want to make it appear that we are transparent. Well, let's make a motion to federal judges that we want the grand jury testimony in the Ghislaine Maxwell and the Jeffrey Epstein cases. Because one, judges may very well say no because it's a hard thing to get, in which case we can just blame the judges and say, look, we wanted to be transparent, but the judges said no, they stopped us. And two, even if the judges grant it, that's not where the bodies are buried. So it was just a frigging ruse. And you know how you know that, Mary? Because the reporting is that there are 2 to 3 million documents that have not been turned over. And I have to tell you, I was thinking about the question I'm going to ask you at the end about what you would ask. If you gave me a choice of 2 questions,
Right.
this would be number 2. Are you willing to tell us under oath that Donald Trump's name is not on any of those documents that are undisclosed? Yes or no?
And I suspect he would not answer with a yes or no. What do you think?
Oh, yeah, he wouldn't. But that itself is the answer. That's how you'll know.
And I will note that a number of the victims of Jeffrey Epstein have come out very publicly, very strongly against Todd Blanche's nomination. So that's one whole area that I think we will see questions, and those questions are very appropriate to ask of Todd Blanche.
Since we do things that are very detailed, there is a discrepancy. One of the things that Todd Blanche and Pam Bondi had said about things that they have not produced is when it was a complete duplicate document,
Right.
they didn't produce it. But when you look at Katie Fang's lawsuit, that's not what they're saying there. They say that they did not produce interview notes as opposed to the final reports because there's substantial similarity between one and the other.
Now, is that a duplicate or is that just, oh, you know what? This one's more detailed. We won't reveal this one. We'll reveal the final report.
Like, I'm sorry, who's making that decision? It also just strikes me as, you know what? Who cares? Whether it's a duplicate, then turn it over. And if it's substantial, well, fine. You know what? I read the Epstein Transparency Act. It didn't say, by the way, you don't have to produce things if you unilaterally determine that they're duplicates or substantially the same. We don't want you to be making that because is it substantially the same because one has Donald Trump's name in it and the other doesn't? Remember, that was
Right.
they produced a number of things,
Yep.
but the ones with Donald Trump's name in it says miraculously had not been produced,
Mhm.
claiming, oh no, it's a duplicate. So this is not fanciful to be concerned about this.
100%. And I am sure we will see a lot of questioning on this by Republicans and Democrats, because this is something that has been non-political in terms of, this is something where Congress was actually able to legislate the Epstein Transparency Act in a year where Congress is not able to legislate very much at all, but that's because we had at least some of the Republicans coming together with Democrats to demand that this be made public.
Isn't the confirmation of Donald Trump, I'm sorry, isn't the confirmation of just interesting Freudian slip,
It is. It
isn't the
is.
confirmation, I mean, in some ways, I would say to our producers, leave that
Leave that
in.
in. Exactly.
Wouldn't the confirmation of Todd Blanche, one way to frame this, if you are against his confirmation, as I am, is if you are confirming him, you are confirming a lack of transparency in the Epstein matter, and that it's okay to unilaterally violate the law, the Epstein Transparency Act, and have no consequences. And so you are either with us or against us. In other words, there's no two ways about it. If you confirm him, you are never going to get those documents, and you are saying it's fine. Is that what side you want to be on when you just voted almost uniformly as members of Congress that you wanted complete transparency?
100%. Okay, let's talk about some other things. Under Todd Blanche, and you listed this in your lengthy list, we have seen just political prosecution after political prosecution after political prosecution. I think in many ways, the reason, maybe the primary reason that Pam Bondi was fired is that she was not able to deliver on the president's desire that his enemies be prosecuted. And we have seen Todd Blanche embrace that directive ever since the day he took over as the acting AG. He was obviously working it as the deputy, but has been much more vocal about it, to the tune of even saying publicly that Americans should be happy that the president is directing the activities of the Department of Justice.
That type of communication from President Trump should make every American happy, because it means that there's an executive, a chief executive, that is making sure every one of his cabinet members are working as hard as they should.
And saying that it is the president's right and duty to direct the Department of Justice in terms of investigations and prosecutions.
That's what being the commander-in-chief is about. I mean, I think the fact that he encourages or directs or expects the Department of Justice to do its job, that those type of messages do not faze me. As a matter of fact, I want a president that does that. I want a president that actually sets his agenda and then sticks to it.
So, Mary, one of the things that I think it's really important to see Todd Blanche's sleight of hand. There's one thing to say that the president has the power to do something when the issue is whether it's wise, whether he
Exactly.
should exercise it. All of the post-Watergate reforms are not about could Richard Nixon or a subsequent president control the Department of Justice. It's a question of whether it's appropriate to control them on the question of who gets prosecuted and who does not get prosecuted, as opposed to policy issues, big policy issues. And so for Todd Blanche to prevaricate on this, again, my view, and say, oh, no one can deny that the president has that power, is not actually answering the question and is so dangerous because it's not getting to the real issue here.
That's right. And that is an important distinction because, as the Supreme Court has been telling us over and over again, and as we know from the Constitution, there is a constitutional impediment to actually having a break between the Department of Justice and the White House. And that's because the president is the chief executive of the executive branch. The Department of Justice is part of the executive branch. Even without the robust unitary executive theory that this Supreme Court has embraced, you still have that basic constitutional feature that the president could, in fact, under the Constitution, direct his attorney general to engage in whatever he thinks his attorney general should engage in. But we know that since Watergate, at least, presidents and attorneys general have said we need to do something different because of the perception. It's the policy choice that you indicated. And I just want to quote again, this is Attorney General Bell right after he's the one who instituted this first White House context policy. And one of the things he said, this again, right after Watergate, is the president is best served if the attorney general and the lawyers who assist him are free to exercise their professional judgment. And just as important, they must be perceived by the American people as being free to do so. And that's the independence that we're talking about that we just don't have here. And that is the independence that Todd Blanche apparently seems to think doesn't matter at all. This idea that it is important to be perceived by the American people as being free to exercise its own independent judgment, something that has been embraced since the 1970s. And I would argue even before that to a certain extent, but Richard Nixon broke from it with Watergate. Todd Blanche isn't even pretending to have any allegiance to that. He's to the contrary. It's the president's right and duty to direct the Department of Justice as to what to do. And there is a distinction between directing policy priorities, right? I want the Department of Justice to put more resources into transnational drug trades or transnational
Or
human
immigration.
trafficking or immigration. That is fine. But when he says, I want the Department of Justice, hey, Pam, you're not going fast enough on prosecuting Jim Comey or Letitia James or Adam Schiff, that is a very different thing than a policy priority.
Or back off on the Proud Boys and Oath Keepers and any pending case that exists, you need to dismiss those.
That's right.
That is both the White House not seeing any separation and Pam Bondi and Todd Blanche not seeing any separation and being more than willing to do it. Remember, it is Todd Blanche and Pam Bondi and the President of the United States who have all called the prosecutions of the people on January 6th a grave national injustice. If I had to pick a third thing to ask Todd Blanche about, I would say, can you walk me through why it is a grave national injustice to prosecute somebody who attacked police officers and the Capitol Police, who defecated in the Capitol, who were so violent and defiled the symbol of our democracy and the peaceful transfer of power? Can you walk me through why the person who says that is a grave national injustice is entitled to be the head of our Justice Department?
Yeah. Before we break, let's just also be very plain about what has happened with respect to those prosecutions under Todd Blanche. It was the president exercising his pardon power on day one of his administration, right, to pardon, commute the sentences, and order the dismissal of cases that had not yet gone to conviction. But even after pardons and commutations, it's under Todd Blanche that the department attorneys were directed to dismiss the cases where defendants had been convicted and not been pardoned. So these were Proud Boys and Oath Keepers convicted of seditious conspiracy. They agreed to dismissal of those appeals in those cases so that they could go back down into the district court and the government would move to dismiss those indictments. These are cases where the president hadn't even actually pardoned people. He had issued a commutation, meaning your conviction still stands, but I'm ending your sentence as of today. You don't have to serve any more time. It's under Todd Blanche that he went back and ordered department attorneys to move to dismiss those cases.
With prejudice.
With prejudice, meaning they could not ever be brought again. And this is where we have seen two federal judges take slightly different tacks here. Judge Maida, who had presided over the Oath Keepers trial, he says, I want to get some reasons from the department before I dismiss these cases. Granted, under the rules, I don't have a lot of discretion here, but dismissal is with leave of the court. And I want to understand how this is in the interest of public safety because the government, you haven't given me any reasons. And then just this week, we had Judge Tim Kelly, who presided over the Proud Boys trial, who said he didn't really think he had very much discretion to not dismiss the case. And even if he didn't dismiss it, the government wasn't going to retry it or anything like that now that the judgments had been vacated by the Court of Appeals, again, at the direction of Todd Blanche agreeing to that in the Court of Appeals. So he did not ask for more briefing by the government. He did grant the motions to dismiss, I will say with some reluctance, and I think it's worth noting what he said about this.
Yeah, it's quite poignant.
Here's what he said. As the court has said many times, the attack on the Capitol on January 6, 2021 was a perilous event. It was an attack on people, including police officers, many of whom were injured. It was an attack on a coordinate branch of government, Congress, that the founders saw fit to give a place of primacy in Article 1 of the Constitution. And it was an attack on the Constitution's mechanism to facilitate the peaceful transfer of power from one president to the next, what President Reagan called nothing less than a miracle. But this is all under Todd Blanche.
Absolutely. Mary, let's take a break. And when we come back, I'd love to hear your thoughts about looking forward if Todd Blanche is confirmed, what do we think it means for the midterms and how the Department of Justice will act? And what has he done to date that gives us some clues and some tea leaves to read about that issue?
Yes, that sounds like a good idea.
Welcome back. Mary, Todd Blanche has said some things about the role of what I'll call law enforcement when it comes to the elections. And I wanted to get your sense of, if Todd Blanche is confirmed, what do you think it means for the upcoming elections? Because we have the example of Bill Barr, who was willing to go very, very far, but ultimately had a line where he very famously said the claims of election fraud in the 2020 election were, and this is his phrase, bullshit, unquote. And we try and keep this clean, but that's a direct quote. And so it's hard to see, given what has happened, all the litany of things that we have just spent 2 segments talking about, that Todd Blanche has any line that would prevent him from engaging in something that Bill Barr was not willing to do. And one of the things I would point to is our discussion last episode to the federal judge appointed by Donald Trump, who quashed the grand jury subpoena looking at alleged election fraud in Fulton County, Georgia, saying that this is all just made up. It's a fishing expedition and there's no good faith, legitimate basis. Again, everyone step back. This is about conduct of the Department of Justice headed by Todd Blanche, who is seeking to become the permanent head. This is what a federal judge appointed by Donald Trump has said about his conduct.
Yes. And I want to know, if I'm a senator, what about this election? If the president says to you, Mr. Blanche, I believe there was fraud in this election, are you going to order the FBI to seize voting machines? Are you going to subpoena election officials? What are you going to do if you have no actual evidence that there was any fraud? If you have no actual evidence that any unlawful or undocumented immigrants have voted, but you have the president who is telling you you need to do something. What are you going to do, Mr. Blanche? Because these are some of the things that I think we need to be concerned about. And that's kind of an after the fact, right? What if the president, who's already alleging fraud, let's just be clear about that. That's after a fact. What about even the things he's going to do before the election? We had Todd Blanche who said, why is there an objection to sending ICE to polling stations?
Election integrity should be the most nonpartisan issue we have. Like, why is there objection to sending ICE officers to polling places? Illegals can't vote. It doesn't make any sense.
Well, we know that sending ICE into cities, and particularly around polling stations, this is an intimidation tactic. There is no substantial evidence of undocumented persons voting in U.S. elections, full stop. Every election official will tell you that. Every DOJ person who's ever been involved in elections until this administration will tell you that. Yet by sending ICE to polling places, you certainly are sending a message of intimidation. People lawfully able to vote, United States citizens who are maybe brown or look like they might come from another country, those are the people who think, you know what, I don't need to get shaken down by ICE today. I don't need to get killed.
Exactly. And there people have actual data to support that fear. The issue with the question to Todd Blanche is that he, of course, can say, well, if there's no evidence, of course I'm going to stand up for it. But here's a guy who was willing to authorize seizing the ballots in Fulton County. He was willing to issue a grand jury subpoena that got quashed. You have somebody who is willing to say, oh, well, there is evidence, in my view, is that he's going to be perfectly capable of saying, whatever crazies are out there, oh no, look, there's evidence. Or, you know what, they have enough ways to create and foment the idea of fraud. All they have to do is ask the Russians, in the same way that Donald Trump asked the Russians for assistance in the election between him and Hillary Clinton. And so you don't think that the Russians or any foreign government that wants to help Donald Trump isn't going to have various claims made about there being fraud and then that being used by this administration? There's just no sense of fair play and them being an honest broker about the facts. That to me is the biggest fear. And that's where one of the things that I think the Senate has to be very concerned about and wary of is Todd Blanche saying things that are completely belied by what he has done. In other words, words are cheap and easy, but here you have a track record.
That's right. And that's also one thing, Andrew, that's different about a year and a half ago in January of 2025 when there were hearings for Pam Bondi and Kash Patel, both of whom were asked about their ability to be independent from the president. And Kash Patel, I remember very directly saying there will be no political prosecutions. Well, that turned out to just be false, a false statement. But here, like you said, the senators don't have to sort of ask and hope that the person's going to tell the truth, because whatever Blanche would say in respect to that tomorrow, if he were to say, oh, no, I will exert my independence and make my own decisions, that's whether it's about political prosecutions. That's also whether it's about the elections and whether there's fraud in the election. How can that be a trusted answer when we already have this track record?
And I think a perfect response to what he might say about that, to say, oh, no, I'll be fair, is I have four numbers for you: 8647. 8647. You tell me that you were trying to be independent of the White House and being an honest broker. You think that that is a valid prosecution of James Comey? If you honestly thought that James Comey was threatening the life of the president, why'd you wait a year
Yeah.
to bring the case?
And then base it on seashells.
Right. I mean, it's just preposterous. Mary, I wonder if you're ready for my question.
See, the problem with your question is that assumes that I have just one question I could ever.
I know. Well, okay. Do you want me to go first about what I would do?
Yes, but there's something we haven't talked about yet. So if we're going to end on questions, can I just
Yeah, okay.
raise one? I
Yeah,
mean,
yeah, yeah.
there's about a gazillion things we haven't
I
kind of
know.
talked about yet. And I would commend to people the list of the fact sheet on Todd Blanche's devastating leadership at the Justice Department. That's what it's called. It's a press release by Justice Connection that we can put in the show notes, because we've only gotten to touch the wave tops, and I haven't even read this whole list, but I've skimmed it and I'm like, oh, this is good. This is good. And almost all of it's on my radar, but if you don't all have it in front of you at one time, you tend to forget it. But one of the things we have not talked about is, under his leadership, the real assault on journalists. And we saw this. Friday was a perfect example. We have
Yep.
the president goes to the NATO conference in his fancy new conflict of interest plane, a gift from the Qataris that he's been bragging about how luxurious and wonderful it is. And then when he goes to leave the conference, he's suddenly taking his old Air Force One plane instead
The
of
old
this fancy one.
decrepit
Yeah, that's right.
Air Force One.
Yeah.
Right.
And mind you, it's not just the president on these planes or the president and his closest advisors. Press goes on these planes as
Yeah.
well. Now, of course, they're back in the back and they only get to talk to the president when he wants to talk to him. But still, they're on these planes too. So it's not as though it's just him. And it leaked, I guess. The New York Times was reporting, based on anonymous sources, that the reason that he flew in the old Air Force One is because the new fancy gift plane did not have the types of actual just external security on the plane that could protect it against things like missiles. And that apparently annoyed the president that this was being reported. Friday, according to reporting, Kash Patel, the director of the FBI, is summoned to the White House, where he spends something like 8 hours. And what happens next? By Friday night, the Department of Justice, through the United States Attorney in the Southern District of New York, Jay Clayton, who has been nominated to be the Director of National Intelligence, and that hearing is also scheduled for tomorrow if it's not postponed, is issuing subpoenas to 4 or 5 different New York Times reporters to testify, actually tomorrow, another thing happening tomorrow on Wednesday, about where they got that information.
And those subpoenas were served by hand at home, is the reporting, which is just not done. It's outrageous enough that you're issuing the subpoenas, but the way it is done is not in that heavy-handed approach. I mean, these people are not going to abscond. It is such an intimidation tactic. And this is one where so far there's no allegation that what was reported was classified information. So there's no known allegation that that's a problem. And this is a real attack on the Fourth Estate. Now, you could add this to a long, long list that could start with Stephen Colbert and Jimmy Kimmel and could go to CBS and ABC and many, many other illustrations.
Search warrants of Washington Post reporters, subpoenas to other journalists, all of that. Yes.
And this is so much in keeping with the idea that Donald Trump has, which is see no evil, hear no evil, there is no evil, meaning if I can get the reporting to not focus on this, if I can just be covered in a glowing way, then no one will ever be confronted with the truth. It reminds me of when COVID was happening and people were saying, well, our numbers are high. And he said, well, that's because we're counting. And the idea was if we could stop counting, that somehow it's not that the numbers would be down, it's that no one would know that the numbers were not down.
Mm-hmm.
And so it's just so much when you lead this superficial way of thinking about the public, which is I control the information flow. Okay, Mary,
Yes.
are we ready?
Yes. Okay. You go first.
Well, I would ask the following, and admittedly, it is somewhat self referential to Main Justice, because I would ask, Mr. Blanche, can you tell me why you issued a letter to Sunitha Dodamani firing her? I'd like to know that. You could expand this because there's so many people who are in this boat, and we have not talked about the devastating effect on expertise and career people. And people remember she was on the show about a month ago to talk about how she is a career Department of Justice prosecutor, before that at the state level. She was assigned to a FACE Act case that she recounted how Todd Blanche had actually said that you may not agree or disagree with cases you're assigned to. You may not like it, but we expect you to do it. Well, just before the case, she was assigned to it to help out because of her trial experience, and she did, and she worked on the case. It's not like she didn't even know, as she said, what the FACE Act was before that. She was just doing her job.
For listeners, Freedom of Access to Clinic Entrances Act. This is about prohibiting sort of the intimidation and harassment and threats toward people who are seeking any type of reproductive care service. That could be you want to get an abortion or you want counseling about not getting one.
So she does the trial, and then she receives a letter from Todd Blanche that just says, you're fired.
Under Article 2, the president's authority.
But no reason given. And what I would ask him is, you say that Department of Justice attorneys are supposed to do what they're told and take cases. Isn't that what she did? And you fired her. How can you say that you want to be the head of the Justice Department when you're firing people for no reason?
It's a good question. And I hope it gets asked. And I'll be very interested in the answer because, like you say, that is one really good example of many, many of these letters that have gone out. I think what I would do is I would have a whole list of questions ready to say, if the president asks you to do X, will you do it? And the gist of my question would be, Mr. Blanche, do you have a red line? Is there anything that this president could ask you to do that you would say no to? And I would go through examples of if he said to prosecute X person, right, who is his political opponent, would you prosecute, even if there was no evidence to support it? If he says there's fraud in elections, I need you to seize voting machines, would you do it if there's no evidence to support what the president is saying? If the president says, I want a grand conspiracy indictment, dating back to even before the Mueller investigation, right? When the investigation was in the Department of Justice before special counsel had been appointed, all the way up through the Biden administration. And he wants that indictment. If the prosecutors who've been looking at it says there's not enough evidence, are you going to say, go ahead and do it anyway, if you can get it through a grand jury? Like, what is your red line?
The problem, of course, is that no matter what he says, the counterexample is 8647. And more than that, you tried to indict 6 sitting members of Congress. So that no matter what he says to, oh, I would never do it if there was no evidence, but we know he would.
That's right.
This is like, look at what I do, not at what I say.
That's right.
And so we know from the 6 members of Congress that they're willing to intimidate and even bring a criminal prosecution that the grand jury rejected. The reporting is not a single grand juror approved of this. And it was for a video that was consistent with the First Amendment and stated, in fact, what the law is and what people are taught in the military. He may try and appear in one fashion. And I think that the way to deal with that is to keep going back to the data that they have from his actual track record.
Absolutely. And one thing we haven't covered at all that I'm sure will get covered tomorrow is the disobeyance of court orders under Todd Blanche, both as Deputy Attorney General and now acting AG. We have example after example after example of
The
courts
war on
saying,
judges.
That's another statement he made to the Federalist Society back in November, that the Department of Justice is at war. He used that term with federal judges, him criticizing them for demanding candor and truth from department officials, and also that there's compliance with their orders. And as we've seen, the presumption of regularity that has been accorded to the department attorneys for decades has just been so eroded that we have judges that say, I just can't trust what you say when you come into court.
One thing will be fascinating, whether the senators get their act together. They're not known for being particularly skillful questioners and precise. I also will find it interesting to watch the many, 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 many things, what they choose. Because as you can tell from just this discussion, there's a floodgate of issues to choose from. And it'll be fascinating to see what senators think are the most salient, what will resonate, what is the most important to them, and what they think is the most important to the public. So that'll be a fascinating thing to watch. Bill Barr has said, well, maybe you should confirm him because he's going to be better than who we might get next. In other words, it's the devil you know. And the answer to that is that if you confirm him, it is the seal of approval.
That's right.
And it is much better to say, no, we're not good with this. And even if he remains in an acting position, it is the Senate standing up saying, no, whether it's we're on the side of victims in the Epstein matter, we believe in the rule of law, we support judges, whatever I could go on and on and on. But the Bill Barr argument, I think, is really specious.
It would be abdicating the role the Constitution gives the Senate, the advice and consent role. And you're right. If he could still, because under the rules, he can still remain acting for certain periods of time. If he's denied and somebody else is nominated, the Senate can refuse to confirm that somebody else, right? I mean, that's the job of the Senate. They're sending a message. I hope that what we'll see is actual questions, demanding responses, and not just speechifying by the senators. There's always a certain amount of that. I think that we need to hear as many words out of Todd Blanche's mouth as possible to give people a chance to then write to their senators, call their senators, and make their opinions known.
And that maybe is a good way to end, which is that for people listening to this, whether you think you're in a blue state, purple state, red state, it is really important, if you have views on this, to let your members of Congress, particularly in the Senate, know your views. Getting them to understand how much you care about it is important. So not just your views, but politicians think about, well, how much is this really touching a nerve for people? And so there are lots of things that you can do to speak up and speak out if this is an issue that you care about. Obviously, you can hear from Mary and me, this is so dear to what we've done for a living our entire adult lives. So with that...
Well said, well said.
Mary, thank you everyone for listening to our 200th episode. And remember, you can subscribe to MS Now Premium on Apple Podcasts to get this show and other MS Now originals ad-free. And you'll also get subscriber-only bonus content. And a reminder, we are also available on YouTube. Head to ms.now/mainjustice to listen.
This podcast is produced by Vicky Vergolina with support from Donnie Holloway. Nicholas Vinuela Yodar is our associate producer, and Cassidy Corey is our intern. The audio engineers for this episode are Bob Mallory and Hazik bin Ahmad Fared. Katie Lau is the senior manager of audio production, and Aisha Turner is the executive producer for MS Now Audio.
Search for Main Justice wherever you get your podcasts and follow the series.